Hi, Contract MVPs. It's Foster Sayers, General Counsel, Chief Evangelist for Pramada and Contract MVP. Today, I'm not going to bring you a tip on commercial agreements. I'm going to do something different. I'm bringing you a special tip in response to the tech layoffs that have been announced in the recent weeks and continue to be announced. So we're going to talk about severance agreements. And especially if you're over 40, I want you to know your rights. So under the Age Discrimination in Employment Act, as amended by the Older Workers Benefit Protection Act, there's a mandated statutory consideration period that you have to consider any severance agreement. If you're 40 or older, you must be given 21 days to consider the employer's offer, unless it's part of a group termination. And guess what? In a layoff situation, it's going to be a group termination setting. And in that case, employees must be given 45 days. If you have accepted a severance agreement and you feel it was not the right call, and you are still within the 21-day or 45-day period, you can revoke that. Okay. Now, you might be saying, this is great, Foster, but I'm under 40, unlike you. What can you do for me? Well, if you're under 40, don't rush to sign any severance agreement, okay? You're allowed to have a reasonable time to consider them, and you can even ask to have the time afforded to your older counterparts. It's really to your employer's benefit to give you that time because the enforceability of those severance agreements, even when under 40, still requires there to be a nexus of reasonableness with the consideration period that's been given. So to all of those who are impacted, I hope this information is helpful, and please share it to anybody else that you think would benefit from this tip on severance agreements.